How did medieval legal theories develop? Imagine a time when laws were not written down, and every community had its own set of rules. This was early medieval Europe, where legal systems were based on local customs and traditions. These unwritten laws varied from one region to another, creating a patchwork of legal practices. The leges barbarorum, or laws of the barbarians, were examples of these customary laws that governed daily life. As the Carolingian Empire began to decline, the rise of feudalism shifted legal authority to local lords. Each lord had the power to enforce laws within their own domain, leading to a decentralized legal system. This meant that justice could look very different depending on where you were in Europe. A significant change began with the rediscovery of Roman law texts. The Corpus Juris Civilis, compiled under Emperor Justinian in the 6th century, provided a systematic legal framework. By the late 11th century, the University of Bologna emerged as a key center for studying these texts. This revival of Roman law principles laid the groundwork for a common legal foundation known as ius commune, which influenced secular law across Europe. At the same time, canon law, the legal system of the Roman Catholic Church, was being organized. Gratian's Decretum, created in the mid-12th century, was a landmark work that compiled church laws into a coherent system. This canon law emphasized the authority of the Pope and often reached into areas like marriage and inheritance, which were traditionally seen as secular matters. The establishment of royal courts also played a role in shaping legal theories. For instance, King Henry II of England introduced the Assize of Clarendon in 1166. This expanded royal judicial power and introduced the jury system, a key component of criminal procedure that we still see today. The Magna Carta of 1215 further influenced legal thought by asserting that even monarchs were subject to the law, promoting the idea of the rule of law in Europe. Trade and commerce also had a significant impact on legal development. Merchants created their own customs and practices, known as lex mercatori or merchant law. This governed commercial disputes and can be seen as an early form of international law. Over time, medieval legal theories transitioned from a mix of local customs and feudal practices to more unified and codified systems. The revival of Roman law, the systematization of canon law, the growth of royal authority, and the emergence of commercial law all contributed to this evolution. These developments laid the foundation for the Western legal tradition, blending secular and ecclesiastical elements within a framework influenced by education and philosophy in medieval Europe.